License agreements. What are they? License agreements are basically renting your intellectual property to get passive revenue, which is known as a royalty. So if you can license trademarks, patents, patented technology, copyrights, trade secrets. Theoretically, any of your intellectual property can be licensed, and it's basically it's like renting it. So you can sell it outright, which means you no longer have any rights to it, or you can license it, which means that you do retain rights to it, but you're letting someone else make money from it. That can be exclusive or non-exclusive, even to you. So you could say, you know what, I'm not interested in doing this business myself, but this big company that can benefit from my technology is. So you're going to give them an exclusive even to you, which means you just get the passive revenue and they put it into production and do all of that, and they pay you a percentage. So that would be an exclusive as to you. Or it can be non-exclusive, both as to you and as to others, meaning that you're using it for this industry or in this geographic area, and you're going to let someone else potentially have the exclusive for this other industry or this other geographic area, or you can have it be non-exclusive in general, which means that you can license it to every player so that everybody can do this. Can use this technology or this trademark. And very often what we see actually is that we have licenses to intellectual property that involves both patented technology, maybe even some trade secrets, and also some trademarks. Because for instance, like Intel or something, if you are making a computer and there's lots of components from different manufacturers, there may also be some other technology that you're licensing. Some of that technology will come with the right and maybe probably even the obligation to use their trademark on the product and in the marketing of the product. So again, they can be simple, they can be more complex, they can be shorter or longer. The important thing is that it's clear that you really think through who has the right to do what. And whether those rights are non-exclusive or exclusive. When it comes to like fixing the royalty, you need to know like a percentage of what. Is it a certain number of dollars per unit? Is it a certain percentage per unit? If it's a percentage, is it a percentage of a wholesale price or a retail price? And what happens with certain kinds of promotional things? Do they have to pay a royalty, or is it only when it's sold? There's lots of different terms that can come up in there. But none of it is rocket science. It's just you want to make sure it's clear. There's no particular magic language. So if you don't understand what the term says, either ask or cross it out. Like ideally ask. There's nothing to be ashamed of for asking, what does this mean? I would really encourage you to make sure that you understand the terms before you sign any contract, of course, but license agreements, because there can be some jargon in there that is new to you and some kind of different concepts. If you haven't been through this before, especially with your first one, make sure that you ask so you know what you're signing, and you can always negotiate it. It's expected even when you're dealing with a larger company. If you're doing a license agreement, it's going to be negotiated generally if it's your technology. Again, bargaining power. If you have less bargaining power, then less leverage than the other side. I mean, you may be a really small company or solo inventor compared with the big company, but if they really want your technology or they really need it, then you do actually have some leverage. And so don't let their size, make you not stick up for yourself, I guess is what I want to say. Make sure that you understand and that you're getting what you feel good about. A couple of things, boy, it's already getting long here. Okay, so that's the main point I wanted to make, is that license agreements are a way to rent your intellectual property so you get passive revenue, whether you are using your technology or not. And again, that can be for trademarks as well. Oh yes, so one other thing with trademark licenses that's specific to trademarks that's really important. It may be tempting to just license your trademark to whoever just to get extra money from anyone who wants to use your trademark. If you do not have quality control in those license agreements, if you have absolutely nothing that gives you the right to say, no, this is not up to my standards, and terminate the license, what you end up doing is you destroy your trademark rights. It's called a naked license, and you will destroy all value in your trademark, and actually legally you'll lose your trademark. So don't do that. I'll do another video about why it actually does make sense under the legal framework for trademark law. But keep that in mind. Trademark licenses, you need to have quality control, or you're going to end up losing your trademarks. And so that's kind of my couple of bullet points to think about for license agreements. I hope that was helpful. Licenses are an excellent way to get passive revenue from your intellectual property, whether you're using it or not. Catherine Cavella, IP Works Law. Thanks. Bye.